McConway. Today I'm going to be talking about the Miranda rights, and I don't think they should be read in every situation. This is my audience.
And me too.
First, I'm going to begin with what the Miranda rights are, and they are: you have the right to remain silent. Anything you say can and will be held against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand these rights I have read to you? With these rights in mind, do you wish to speak to me? Next, I'm going to talk about how Miranda rights came about. And it came from Miranda versus Arizona. And with that, Miranda was arrested at his home in Arizona, and he was taken into custody to the police station. He was interrogated by 2 officers for 2 hours. He was identified from the complaining witness that he was the man responsible for what happened in this case. In resulting from the 2 hours that he was interrogated for, it resulted into a signed and written confession. At trial, the oral and written confession was presented in front of a jury, and from that jury, they found Miranda guilty of kidnapping and rape. He was sentenced for 20 to 30 years in prison on each count. On appeal, the Supreme Court of Arizona held that Miranda's constitutional rights were not violated in obtaining the confession. Why cops read the Miranda rights? In order to use the evidence that they obtain in court, they help the person not self-incriminate themselves, and police don't have to read if they are intending. Police don't have to read it if they're not intending to interrogate them. So in other words, if they want to use any type of information they get from somebody in a case, they need to read them the Miranda rights, because if they don't, then they lose everything from the case. They help the person not self-incriminate them, so the person doesn't say anything that will hurt them in the long run. And the police don't have to say it to them unless they plan on interrogating them. Because if they're staying there just talking to the person, then they're just having a normal day conversation. But at any point in time, they feel as if that the person has a link to this case, then at that point in time, they must read them the Miranda rights. And yeah, that's it. Next, I'm going to talk about who needs to hear them and when. Law enforcement agents are required to read them, any type of FBI, detectives, or cops. Only if you're under arrest or interrogated. If you can waive your rights. So if the police officer stands there and reads you your whole entire rights, you have the option to either talk to them or not. If you waive your rights, then you don't need a lawyer. If the Miranda rights are not read, what the arrestee says can't be used in trial. You lose whatever you collected unlawfully. The case will not be dismissed, though. They will continue with the case and try to collect any other evidence after reading them their Miranda rights. And next would be the exclusionary rule. The exclusionary rule is it enables courts to exclude incriminating evidence from introduction at trial upon proof that the evidence was procured in contravention of the constitutional provision. In other words, if whatever the police officers gain unlawfully, the courts are able to use the exclusionary rule to throw it out. It excludes any evidence that they gained. Next, I'm going to talk about a case where this man, Reuben Kenneth Lugin, his Miranda rights were violated. And it is a murder conviction voided over a Miranda rights violation. Reuben Kenneth Lugin killed his wife and her friend, but by by smashing their head in with a concrete brick. Lujan's wife left him months before this killing. He suspected that his wife was dating their neighbor. The neighbor was their friend. The first confession that they gained from Lujan was thrown out because they never read Lujan his Miranda rights. And detectives did not, as I just said, detectives did not tell Kenneth he had the right to an attorney before and during his interrogation, and they did not end the questions when he asked for a lawyer. And within that, he did confess to the murder of both his ex-wife and her friend, and he signed the confession. But from that, since they did not read his Miranda rights, the three-judge panel of the U.S. Ninth Circuit Court of Appeal threw out the first confession because he wasn't read his Miranda rights. I don't think that's right, because he killed two people, and in the moment, since the law enforcement forgot to tell them it, they should not be able to throw out his rights because he confessed to murdering two people. He confessed again, though, during his trial, and from that, he was sentenced to life in prison without parole. But if he did not confess during his trial for a second time, they would have never had a confession from him. Saying the Miranda rights. Cops should only say the Miranda rights on certain occasions. If not said, evidence will be thrown out, such as the case if Lujan didn't confess during the trial, that they would have lost everything. Questions and comments?
What year did the Miranda rights come about?
The Miranda rights came about in 1966 from the case I explained in the beginning from Miranda versus Arizona. Did that answer your question?
Yes.
Any other questions? Yes?
Was there ever a time where officers didn't want to use their Miranda rights or override them?
There was a case that I did research that the case did get, or the Miranda rights, they overruled it, the judge overruled it because there was a case where this mother's son and his friend, they set fire to their family's home, and the intention was to kill her other son, who had if I'm correct, he had like a mental disability. And from that, the police took her to interrogate her. They interrogated her for, I think, maybe 2-3 hours. And that resulted into a confession, a written signed confession. And then after a 30-minute break, they came back, they told her her Miranda rights, and then they had her re-sign it and re-say it to get the confession. And the judge actually overruled it and said that it was okay for them to do that. In my opinion, if they got the confession, they got it. In the moment, if they don't read it, then I don't see the big deal. Because if they confess to killing somebody, then they did. Any other questions? Alright, well, in conclusion, the reason for this PowerPoint was to prove that the cops should not have to say their Miranda rights in every situation, because if they get a confession from somebody killing somebody, then that should be able to be used in court. That's it. Thank you.